annual George Williams Andrew Lynch Constitutional Convention is underway here at the Art Gallery of New South Wales. And the main event, the main item of excitement at the moment is a panel discussion between newspaper opinionist Janet Albrechtsen and Justice Robert French of the Federal Court. Let's take the camera inside and see whether we can pick up any of the excitement.
Now, I know the polite thing to do in such a forum is to play to one's audience, to talk about how brilliant lawyers are and how even more brilliant judges are. But instead, I'll be frank, and if at the end of this discussion some of you have been offended, then I'm afraid I won't be apologising for that. What in fact is the legal profession doing to fix the problem? Nothing. Quite the opposite. The profession is trying to maintain the ability for judges to remain activist by pretending that this is a purely legal issue, a purely technical issue of interest only to lawyers, and therefore to be left up to lawyers to solve. This device of treating the issue as a purely technical issue enables the profession to play its favourite delaying games of obfuscation and complication. Death by definition, I call it. Judicial activism cannot be defined, ergo judicial activism doesn't really exist. It's simply concocted by wicked conservatives such as me who disagree with the substance of particular decisions. Well, I'll return to that charge later to prove that it's a nonsense. It's just another attempt by some in the legal profession to disregard the true importance of judicial activism. If the lawyers in this room come together simply to pontificate about judicial activism as a legal issue, then I think you've got it all wrong. The issue is more about power and politics than it is about law. It's about who makes decisions on key issues, who wields power and to what extent. It's about the legitimacy and community acceptance of our institutions. And if the legal community will not accept the challenge to properly address the issue, but instead continues to dance on the heads of pins, to engage in hair-splitting and denial in the face of clear evidence, I think we will end up with a politicised judiciary. Now, I'd like to call this section the 7 deadly sins of judicial activism, but alas, only a few of them are sins. The other problems are the unfortunate and unacceptable consequences of judicial activism. As I said, this is the easy part, so I'll skip through these quickly. Hubris is the most egregious sin of judicial activists. That judges suppose that they can mould a better world from the bench rather than leaving it up to boring old democratic processes is the height of arrogance. That Parliament's inaction may be deliberate or may reflect the will of the people seems not to matter to these judges. Now, whilst as a journalist I rather like the notion of an implied right to free political communication, that of course is not the point. The ends does not justify the means, so please don't imagine that claims of judicial activism are made when one does not agree with the merits. Wrath. Far from settling a contentious issue, when courts make law in circumstances when they should not, they tend to inflame passions and cause greater divisions over a particular issue. 30 years after the US Supreme Court decided Roe v. Wade, abortion remains highly controversial. Notwithstanding a high level of support for abortion among Americans, there remains a feeling that the court simply usurped the power of the people. After the US Supreme Court struck down laws prohibiting sodomy in 2003, polling revealed that Americans became less tolerant towards homosexuality. And the same backlash was evident in Australia over native title. Sloth. When judges enter politics, they let politicians off the hook on the difficult issues, like Mabo. When things get too hot politically, we might find politicians just handballing subjects to judges. But judges should not be doing the work of politicians. Now, having dealt with those well-known sins, the real problem with judicial activism, of course, is the basic democratic deficit. When it comes to deciding basic social and political issues, how many votes do we want to count? The 7 men and women who comprise the High Court, or the 16 million or so Australians on the electoral roll? Judges are not representative, even if they think they have the finger on the nation's pulse. This is your job. You need to find a test that will ensure that our courts continue to be regarded as impartial, dispassionate, apolitical implementers of the law, not legislators. If you want judges actively to make law, then by all means, let's elect them. That, of course, goes without saying. Thank you.
Much of the debate about judicial activism concerns the interpretation of legal rules and the extent to which they have a single clear meaning or offer a range of possible meanings. In the context of constitutional interpretation, the point was made in 2006 in Kermit Roosevelt's book, The Myth of Judicial Activism, when he said, "The plausibility of the charge of activism depends at least implicitly on the idea that there is a clearly correct answer, frequently called the plain meaning of the Constitution, that judges are disregarded, and the basic reason that the term activism has no place in a serious discussion is that relatively few significant or controversial cases possess clear right answers." The same holds true for the rules of the common law and statute law. Many common law rules use language such as reasonable or unconscionable or foreseeable or remote or good faith. The use of words like these is not a new phenomenon. Let me turn then to the meanings of activism and ask the question, against this plethora of choice-rich decision-making conferred upon the judges as a necessary part of their judicial function, what is there left for so-called activist judges to do that defines them as activists? It's hard to know because there are so many definitions, and coming to grips with them is like coming to grips with blancmange. But let me start with the ordinary meaning of the word activism. In the Oxford English Dictionary, the second edition, it is a doctrine or policy of advocating energetic action. So if you're a judge like me who believes in regular physical exercise, you are a judicial activist. Closer to the present debate is the Macquarie Dictionary definition of activist as a zealous worker for a cause, especially a political cause. But the judge who is committed uncontroversially to the rule of law and the discharge of his or her oath of office would conform to that description. It is always meaningful to ask whether a judge has exceeded his or her proper function by laying down legislative rules beyond the permitted interstitial lawmaking which it is necessary to dispose of the matter before the court. The question may properly be asked in the context of judicial review of executive action whether a judge or a court has entered upon the rather ill-defined territory of merits review and sat in the seat of the executive to substitute its own view of the correct or preferable decision, rather than to stay within the boundaries of review of process and lawfulness. The question may also be asked whether the judge or a court has applied to the task of constitutional or statutory interpretation the principles generally regarded as accepted or legitimate, and if not, why they have been departed from. Each of these questions raises a different kind of legitimate concern. Their sharpness is lost, and the seriousness of the debate about the judicial function which they raise is compromised if they are swept under the almost meaningless rubric of judicial activism. We then get into taxonomical debates of the kind that have raged about conditions like dyslexia, RSI and ADHD and whether they constitute identifiable diseases. There is much concern expressed by protagonists in the activism debate about judges taking over the functions of the legislature and the executive. Now, I did search for documentary evidence of the existence of the mythical monsters known as judicial activists, and I found a very suggestive depiction in Lewis Carroll. Now, the large creature with ambiguous lineaments might be thought, with the use of some imagination, to be a judicial activist. And if you were to put a pen in the hand of the small person heroically confronting him, you might think that's a crusading journalist. I would like to finish this presentation with another two words from the deathless prose of Judge Gregg.
Court's adjourned.